your signature?
Yes.
Good evening, everyone. Along with my fellow commissioners, we welcome you to the meeting of November the 5th. We have roll call, please.
Commissioner Bernardo, Commissioner Brennan, here. Commissioner Holsinger,
Here.
Commissioner Tucker,
Here.
President Caravana.
Here. Thank you. At this time, we have an opportunity for the public to make public comments for items that are not on the agenda. And I have three speaker requests. The first one is Mr. John Olin. And if we have approximately 3 minutes.
That's real short one.
And then Deputy Secretary will announce 30 seconds.
It's a shout out to Ms. Harris. Ms. Harris, I have been so thoroughly abused by other agencies that refuse to give me PRA data. Agencies with people in them who I personally liked and I thought personally liked me. Well, you and I have always had a contentious relationship, and I understand that. But on the other hand, you have always made sure I got that stuff. Whether you thought it was a stupid request or a useful request or thought how I asked for it, never mattered. You always handled it professionally, and I never got just how well you were doing your job until I got done dealing with the city of Half Moon Bay, who after 10 weeks informed me that they just pretty much decided that it wasn't really worthwhile what I had asked for. And they decided not to do it. And so I really want you to know that I appreciate that, and I'll make sure other people know that you took the job that seriously. Thank you.
Next on the list is Mr. Leonard Warren. Mr. Warren, the Deputy Secretary will let you know 30 seconds prior to your time.
What was that?
The Deputy Secretary will let you know 30 seconds prior to your time for 3 minutes.
Normally I would say, good evening, honorable commissioners, but there's only one sitting there right now. It's honorable. Fortunately, the voters understood this, and the back of the arrogant majority is broken, and it'll be interesting to see how Jim Tucker survives trying to bully from a minority position. Because this commission is no longer owned by Jim Tucker, as it has been for 20 years. And one of the, you can start out by directing staff to comply with the California Public Records Act and release the appraisal, which is not exempt from disclosure, because only appraisals that you get for property you're considering buying are exempt from disclosure. You're selling it, it's not exempt from disclosure. You know, you have a hired gun here who does what you want him to do. You know, my dad always used to say, when you ask a lawyer how much is 2 + 2, he says, how much do you want it to be? And that's what's going on here. You need to release the appraisal instead of forcing another government agency to piss away another $6,000 getting their own appraisal because you're crooks and the other district that we're dealing with is also sleazy. And the Public Records Act says it is to be liberally construed in favor of releasing public documents. So this bad attitude, starting with the fact that your meeting started at 6 o'clock, which is very public unfriendly, this bad attitude is what cost you the majority, and you squeaked in by a hair, and that won't happen again. We'll just try a little bit harder 4 years from now, and you'll be out with skid marks. But we've got a 3-time loser here. You're next. You guys need to be more public friendly, and that means well, I'll speak to item 4 later. You need to think about the public for a change instead of just lining your own pockets with your corrupt health care and your excessive benefit, your excessive meeting fees, even if you don't show up for the meeting. The only reason this district isn't going to be dissolved in the next few months is because he lost the election and we got our reform people elected, and by the way, I wasn't the mastermind of this election. I fully supported what happened, except that I'm shocked that Robert lost to you, which proves that maybe money still can buy elections somewhat. But you gotta go, and in the meantime, you guys need to be more public friendly.
And next is Mr. Esther Brown. Mr. Brown, we have policy 3 minutes. Then the deputy secretary will let you know 30 seconds prior to 3 minutes expiration.
Thank you very much. My name is Oscar Braun, and I am the founder and the executive director for the Half Moon Bay Coastside Foundation, doing business as Save Our Bay, California Watershed Posse, and also the San Francisco Peninsula Fire Safe Council. Missions that are all been appointed either by the federal government or by the state government. Water Quality Protection Program, fire prevention, obviously, and one of the 2 remaining private sector coordinated resource management and planning councils. Anyway, I just wanted to come by tonight to introduce myself. I attended the workshop that your consultants had a few weeks ago over at Oceanos, and invited our foundation to join their TAC committee, in which we gladly accepted. So I look forward to working with the commissioners, and I've met a few, and I'm looking forward to meeting the new commissioners and working with you all. Thank you very much.
Okay. Next, Mr. Dan Haggerty.
Good evening, Honorable President and Commissioners. I wanted to say briefly about the post office lot in El Granada. Remind the Commission that the community of San Mateo County, all the citizens in San Mateo County, are trusting that this Commission will do the right thing for all of San Mateo County regarding the post office lot. Now, it has been mentioned over and over, oh, it's in our best interest to collect the highest bid. And you're forgetting that there is a potential for community enjoyment, not only the immediate community of all of the coast side, but also visitors from the other side of the hill that are coming over and want to enjoy the harbor and the beaches. So this is a very large issue, and it should be considered. You should be getting a public open process from members of all of the county, the community members of all of the county. Currently, there's 340 odd local community members that have been outspoken enough to actually put their name on a petition regarding this. And there's been very little effort in getting these signatures. There has been zero effort in getting a poll from the county. Many members I've talked to that come over to the community once in a while, the coast side, and they love it, and they love it for that small town feeling. I meet people coming down from the city that are right there on our 1 block downtown, and they come here, they spend their money, and I ask them, why are you here? What is it about this? And they just say, oh, when I get here, I just, all the load pressure is off my shoulders. I just feel totally relaxed. And there's a reason for that, and we should be focused on that reason. So for this, I urge you, I plead that you do not accept any offers on this property, and that you please call for an open process, public meeting, to have this discussed about how transfer of this land can benefit all the citizens of San Mateo County best, instead of thinking on your own what you think is the best for everybody. So this is very important for everybody, and I don't want the wrong decision made. Thank you.
Okay, one more speaker, Mr. Donald Sheardon.
My name is Donald Sheardown, Miramar. I'm just a regular citizen. First time I come to a meeting like this of the Harbour Commission. I just came tonight to thank the congratulate the newly elected people, Nicole and Tom, and thank Sabrina for Brennan for shedding some light on this commission, which I've been looking into the last year, and it is one of the most disgusting commissions. It ranks up there with third world stuff. The Good Old Boys Network is broken, and yesterday the Half Moon Bay Good Old Boy Network of the City Council is broken. The truth is coming through. You will be exposed for what you've done. That's all. Thank you.
Okay, that concludes the speaker public comments. And now we have staff recognition.
Yeah. Sorry, just a second here. It was for Deputy Harbor Masters Chris Chang and Jerry Pemberton for their efforts to bring a fishing vessel in that was clearly on the rocks, or it would have been on the rocks if they had not rescued the vessel and the people. And that's attached to my report on the back page.
Any other staff? Okay, next on the agenda is the consent calendar. 2 items on the consent calendar.
So moved.
I'd like to pull these off consent.
Please. Which one?
All of this.
Move number 1 and number 2. So let's take them up now. Item number 1, minutes of meeting October 15th of 2014.
So moved on item number 1. Second.
We have a motion and a second to approve item number 1, the minutes of meeting of October 15th, 2014. Discussion, questions?
Just wanted to comment that I am going to vote no on the minutes for the reasons I've stated before, which is that they're incomplete. They don't include public comment, whether the person supported or opposed a particular item. That's all I have to say.
Any more discussion, questions? Okay, roll call, please.
Commissioner Bernardo? Commissioner Brennan? No. Commissioner Holsinger?
Aye.
Commissioner Tucker?
Aye.
President Caravana?
Aye. Item number 1 is approved. Item number 2 on the consent calendar.
So moved. Second.
We have a motion and a second to approve item number 2 on the consent calendar. Questions, discussion?
I'm going to vote no on item 2. As I stated before, I think that the changes that are being proposed here should apply to all commissioners, not just newly elected commissioners. And I also think that we should be, as commissioners, able to opt in to the insurance coverage if we pay for it. And there's no provision for that. So for those reasons, I'm going to vote no on item 2.
Any further discussions, questions? Okay, roll call, please.
Commissioner Bernardo? Commissioner Brennan? No. Commissioner Holsinger?
Aye.
Commissioner Tucker?
Aye.
President Caravana?
Well, item number 2 carries. Item number 3 is informational report and procedure regarding billing for legal services. Mr. Council Miller.
Good evening. In the last meeting, Commissioner Bernardo asked for us to submit a brief description of how it is that we prepare our invoices for consideration by the district, and I included in the packet what I hope is responsive to his request, and I'm happy to take any questions you may have about it.
Mr. President, it's my understanding that Commissioner Bernardo is caught in traffic, and since this was his request for information, I'd ask that this be passed to the end of the agenda to give him a chance to be here.
And I agree.
I accept it. Okay, let's table this until the next meeting. Item number 3 will be tabled and continued.
To the next meeting or later in the meeting?
Let's do a later meeting. If he doesn't show up, it'll go to the next meeting. Okay, item number 4, policy and confidential communication. We have a public speaker, public comment, to request from Mr. Leonard Warren.
Did you have the staff report first?
Yeah, could we please have a staff report?
I would like for you to speak first.
He doesn't know what he's speaking to, and we haven't had a staff report first.
Well, continuing on in your adamant public unfriendliness, have the speakers before the staff report. That's lunacy. That's contrary to every other government agency. What I would suggest for this item, since this is a lame duck board, quack, quack, is that you hear the staff report and take no action on it. There's no reason, because in January, all the idiocy that you clowns have been doing for the last few years is going to be undone. And so it is completely pointless for you to take any action on this item. Censure is hilarious anyway. If I was in Commissioner Brennan's position, I would go trumpet it countywide if you clowns censured me. I would wear that as a badge of honor to be censured by you guys. So there's no point in you taking any action on this item. The one thing I would ask, which you guys won't bother to do, so I'll have to do it here, is in the staff report, which I read when the packet first came out, he mentions and then completely ignores it for the rest of the staff report that information that is not allowed to be discussed in closed session is not protected by any closed session restrictions. So if you discuss something in closed session illegally, any commissioner not only can, but is required to point that out in an open session in public, that you illegally discuss something in closed session. So knock yourselves out, continuing on this path to try and paint one commissioner into a corner, but now you're going to be the one painted into a corner.
Okay, so at your request, President Carvano, we have researched and reviewed both the law as well as numerous other public agencies' procedures regarding the protection of confidential information, and are prepared for your consideration of a memo, as well as a draft of a policy in the memo. Perhaps unlike the last item, which I just left for your questions, I'll just highlight a few quick things. The first is that the memo treats separately communications that are confidential because they are conducted in closed session and are subject to confidentiality under the Brown Act. And a separate issue is communications that are confidential because they are subject to the attorney-client privilege. Some, but not all, Brown Act closed sessions are attorney-client privileged, but all attorney-client communications is privileged. The other thing that I hope my memo makes clear is that with regard to the attorney-client privilege, the client is the entity, and so no individual person can waive that privilege. The entity speaking through a majority of its board is the only person who can waive that privilege. As I also think my memo indicates, the only action that the district really can take with regards to disclosure of attorney-client privilege communications, and this is reflected in what I think is the case in other agencies that have adopted similar policies, is public censure of a board member who discloses attorney-client confidential information. Under the law, public censure is an extremely serious matter that has reputational issues for the elected official being censured, and therefore, in California at least, courts are quite protective of such a person, an accused person's due process rights. And so it's not a matter to be taken lightly, but there needs to be notice and an opportunity for the accused unauthorized disclosure to have notice and an opportunity to be heard. So I think that's all in my memo. I have a number of questions. I was unable to provide for you a policy for you to simply adopt thumbs up or thumbs down. I tried to create a policy that highlighted certain questions and certain paths that you could take. And it is, I think, would be appropriate to have a discussion about those paths, and then you could direct me to come back at a later date with a further policy. You could direct me to study it further, to come back at an unscheduled time, or we could have this discussion now and we can make certain changes. And I have my pen, and we can try to draft a policy that shows you various options and asks you specific questions. I'll pause there both for questions, but also to seek your direction as to whether you want me to go through the questions that I have one by one, or whether you want to consider them through some other process as you wish.
I'd like to have you go through your questions one by one, so that the public is aware of what your questions are.
So the first, I think, biggest issue in my mind is whether you are looking for a policy that allows you to take action for disclosure of all confidential information, in other words, attorney-client privilege communications, as well as closed session communications under the Brown Act, or whether those are separated out. And the reason for asking this question is that the Brown Act itself, unlike the attorney-client privilege, which I earlier said, really the only thing you can do is censure something. The Brown Act itself has in the Act a number of actions that the board can take. It is not an exclusive list, so it doesn't preclude you from censuring someone, but there are things that are available to you if you feel that confidential information from a closed session has been disclosed. So question one would be, are you looking for a policy that encompasses everything, or are you looking to carve the Brown Act issue out and focus only on attorney-client privilege communications?
Could you explain to the board the difference between disclosing something confidential in closed session and abiding by the Brown Act and reporting when the Brown Act has been violated in closed session? Could you explain the distinction?
Sure. But let me preface it by saying that, like any law, this is an area where there is some gray and some shading. So what I'll give you is my interpretation, and I think I would be quite comfortable saying that this is commonly accepted general practices, which is that if I understand your question, it is what's the difference between disclosing confidential communications in the Brown Act and disclosing information that should not have been said in the closed session Brown Act? I'm understanding your question.
Right, because the Brown Act requires that you not keep it a secret. If the Brown Act has been violated in closed session, you must report that. The Brown Act specifies that, because otherwise, how else would the Brown Act be enforced if not to disclose that something that violated the Brown Act happened? So there has to be a way to enforce the Brown Act, and so there has to be a disclosure that something improper happened. So if you could just explain that in detail, that'd be great.
So I do understand the question. Thanks for the clarification. So there is a difference between expressing an opinion as to the nature of allegedly improper communications that happened in a closed session and actually stating and repeating what happened. And the reason for that distinction is because, and maybe it's hard to do this hypothetically, so let's take an absurd example. You go into a closed session and someone says, I like vanilla ice cream. And let's just assume that you weren't supposed to say, I like vanilla ice cream in the closed session. Or let's assume that Commissioner Tucker thinks that the Brown Act says you shouldn't say, I like vanilla ice cream. He may or may not be correct. He is entitled to his opinion. The Brown Act protects him from offering an opinion that the nature of the communications We went into closed session to discuss a real estate transaction, and it's my opinion that the nature of our closed sessions exceeded the scope of what's permitted under the Brown Act. It would be a very different way of reporting the violation in public than saying, we just went into Brown Act and somebody said, I don't like vanilla ice cream. Because he may or may not be wrong, he may not be right. Whether or not it is a confidential protected communication under the Brown Act is not always a black and white issue. So the Brown Act is not a literal document that every word of it is gospel that can be always understood only one way. There is inevitably lots of gray area, and the spirit and the purpose of the Brown Act is always given great weight in determining how things are treated. So I think if you have...
So let me just clarify. So if I'm understanding you correctly, what you're saying is that if you believe that there may have been a potential Brown Act violation, you're to report out that you believe that there may have been a potential Brown Act violation, but you're suggesting that you should not disclose what exactly it was that you thought violated the Brown Act.
Not in public. You are permitted, what the Brown Act says is that you can make an opinion as to the nature of the violation publicly.
Just a general description.
Right. And you can make a confidential complaint directly to the district attorney, at which point one would inevitably need to say, Mr. Holsinger said, I like vanilla ice cream, but that in the context of a confidential complaint to the district attorney is a different matter than publicly disclosing that Commissioner Holsinger said, I like vanilla ice cream, don't know nothing personal, because it's really an unknown question of law, and there may be differing reasonable opinions as to whether I like vanilla ice cream was in fact a proper topic for that closed session or not. And there may be reasonable people can often disagree. And that's why there are, lots of case law on the Brown Act, because it sometimes takes a judge to decide what is the law and what is not. And so the Brown Act does not contemplate individual commissioners deciding for themselves what is confidential and what is not. Does that help to explain the distinction?
It does, but you haven't provided us with any quotations from the Brown Act that...
Well, here, I need to interrupt.
Yeah, do you have something?
So the first page of my memo says, Section 54963 states that an agency may not take any action against a person for the following. And then the first thing says, you can make a confidential inquiry complaint to the district attorney. That's the first part I said. And then the second bullet talks about expressing an opinion concerning the propriety or legality of actions taken by a legislative body in closed session, including disclosure of the nature and extent of the illegal or potentially illegal action. So that's precisely the distinction that I'm talking about.
So you can report out the nature of it, but just not the specifics.
That would be my view, yes.
Your interpretation.
I would say that's, I've never heard anybody have a different interpretation, let's put it that way.
At the last meeting, when I brought up concerns I had about two potential Brown Act violations, which is what spurred President Parabano to request this agenda item, I gave what I thought was a sort of vague description of, I didn't give the specifics of exactly what was discussed in closed session. I just gave a general description. So I think that definitely falls within this thing that you're describing. So I think it's pretty clear, like, if I had gotten into the nitty-gritty specifics of exactly who said what, I could understand where that would have been potentially inappropriate, being that I'm not a judge and I don't know for sure. I think there was 2 Brown Act violations, and I think it's my duty to report that and to let people know that publicly. And I think it's important that those things not happen. And I don't think that they would stop happening if it wasn't reported. But I think in keeping my description generalized, it met with what you're describing here in section 54963.
So I don't want or need to replay past history, but I just want to say that I view my role, while I am also not a judge, I do view my role, and I want you to know that, as offering my legal opinion, which is presumably expert enough, which is why you hired me, and I'm sort of marinating in the Brown Act and I'm not making this stuff up. So I see my role as offering my legal opinion on how to interpret these admittedly gray areas. And my memory of our last encounter 2 weeks ago was that I had a different feeling from you and felt that you were getting into the specifics. And so I recall that I spoke up and said, hold on, could you please stop, and there's another way to address your perceived violation. So I just throw that out there that I will continue to offer my opinion. The second thing I want to say is that this is exactly why due process is so crucial, because now let's turn from the I like vanilla ice cream to the issue that happened last week. Should there be such a policy, and should there be an attempt to censure you for having said what you said, there would have to be a careful examination of the facts of what happened, and you would have to have plenty of opportunity to make your intentions and your opinions and your position known.
And how would that, because this policy that you, well, I also don't recall that you were supposed to be coming up with a policy. I thought you were just going to give a report, so I'm not sure where the policy came from. But the policy that you drafted doesn't get into any specifics about what that due process would look like. So how could we move forward with a policy that doesn't include due process?
Okay, so that's a great question, and that is one of the questions that I had. There are two, the fundamental truth under the law is that due process must be followed. A policy does not need to specify exactly what process is due. Different process, a person is entitled to different process when they are subject to the death penalty than when they are getting a parking ticket. The due process is not a one-size-fits-all type of situation. So one could have a policy that says, as this one does, that any censure proceeding will be conducted in public at a duly noticed meeting. No public censure will occur unless the accused commissioner has been provided with notice and an opportunity to be heard. Notice and an opportunity to be heard are the two key components of due process.
And who would decide the due process?
One of the dilemmas that I faced in drafting this policy is that it's hard to determine what process would be required for every single factual circumstance. So one sort of philosophical approach to the policy would be to keep it broad, and depending on the individual facts and circumstances, you would rely ultimately, I think, on your legal counsel for what kind of process is due under these circumstances, such that a court ultimately will agree that you provided sufficient due process, and that might differ depending on the facts and circumstances. On the other hand, you could have a policy that says we are always going to go through these 5 steps. We're going to hire an investigator. We're going to have 3 public hearings. We're going to have 20 minutes for this and 10 minutes for, you could get very detailed, which in my experience has advantages and disadvantages. There may be unintended consequences. It may not be the perfect procedure for every factual scenario, and so you'll come to a point when you'll wish we had something broader so that we could have crafted something a little more flexibly under these particular circumstances, and you felt handcuffed by too much specificity. And that is really a policy call for you. So on my memo, you'll see I've asked a number of questions about just what you're asking.
Could we go to the second one, the second question?
The second question.
This one's on the policy regarding, does it cover the closed session or specifically the attorney-client communication? So you started that you had questions.
Oh, I see. Okay. So the first question is Brown Act only or confidential community or attorney-client privilege? Second question is what kind of policy, what kind of procedures, how detailed do you want your procedures to be? And I've listed A through G on page what I see on my memo, it says page 1, but it is the third page 1. Apologize for that, I said one at the bottom. But A through G.
Maybe you could just read them.
Sure. First question is, how is an allegation of a violation of the policy submitted and to whom? Should there be a formal process for alleging a violation? Second one is, are there requirements for the specificity of an allegation and any supporting evidence before it is considered sufficient to warrant an investigation? Can anyone just say, he leaked information, that's enough to start this whole process, or does there have to be a sufficiency of evidence to make sure it's not a frivolous complaint? Are there specified procedures for the investigation of an allegation? For example, you could create, whenever there's a complaint, you could create an ad hoc committee that would consider the evidence. You could always refer a matter to an outside investigator. You could convene a full board hearing about it. Next question, are there timing requirements for notification of the accused commissioner? You must give the accused commissioner 7 business days to respond, 3 days, 3 months, some timing. Next question I had was, are there specific rules regarding the conduct of a hearing on the censure, or is it treated like any other action item on the agenda? There are cities and special districts throughout California who just treat it as they go through it as any other item on the agenda, but some have actual formal hearings with separate public notice procedures. And then the last question was, if there is censure, do you want to specify that it be in the form of a resolution, or do you want the flexibility to have, I don't know, different levels of censure, so there could be a motion to censure as opposed to a resolution to censure? My research of what's out there shows that some agencies do one, some do others, some do both.
And so, given that we have one more meeting, do we have one more meeting before the end of the year? Two more meetings. If it was this board's desire to censure me, how would that process unfold between now and, we have a new board coming up in January, so would this be some sort of like super fast track censure process that would require a bunch of special meetings to have a censure hearing, or how do you envision this thing rolling out?
Well, I don't envision anything. At this point, my focus was on drafting a policy for you to consider adopting. Should you adopt the policy, it would be up to the board to determine what to do with that policy. I would view my job as making sure that A, you followed your policy, and B, that should the board determine to conduct some kind of censure proceeding, that it was consistent with due process. I certainly would not.
So you would be in a position of sort of judging that due process, whether we were meeting that?
I'm not sure I would call, I'm not sure I would imagine my role as judging, but I would be advising you that what you're doing is consistent or inconsistent with the law.
Oh, one last thing. You mentioned that you did a bunch of research and that you were looking at other agencies that have similar type of policies. Could you tell us about the research and who has what and that kind of thing?
Sure. I'm not sure off the top of my head I can tell you all the details. And no one has anything similar to anyone else because they are all sort of unique situations. I have also cards on the table. I've been involved only once. It's pretty unusual. I've only been involved once in a censure proceedings with a school district in the east side of San Jose. There are a number of cities in Southern California. I think it's safe to say my research has indicated that public officials tend to get censured more in Southern California than in Northern California. Not sure why that is. A bunch of Orange County cities, Costa Mesa, Rancho, Palos Verdes, have policies. The city of San Jose has a fairly significant censure policy for its public officials. City of San Francisco has a mechanism for dealing with unauthorized disclosures of attorney-client privileged information. In terms of special districts, I did find a couple of cities in Yolo County Special districts, I think that may have been limited to school districts. I don't pretend that I conducted an exhaustive search. I just went on Google and did the best I could, but I didn't think my chart, I didn't want to, I'm not suggesting this is exhaustive.
So you didn't find out many for special districts?
School districts,
And then how many hours does work take, this policy drafting?
I don't know, I don't remember off the top of my head. But it was challenging, the drafting of the memo and the drafting of the policy itself. I wanted to make sure I knew I was anticipating possible questions like this and wanted to make sure I was in a position to be able to answer them, and it was not a simple matter.
Thank you.
Commissioner Tucker.
First of all, I'm not aware of any thought or movement or questioning about censure for anyone. I've not heard that. I don't think that's come up, not to my ears anyway. But censure is a tool that's available. Doesn't need to be qualified in or codified in the statement, as I understand it. You can just censure or choose not to censure. Censure is probably the most difficult thing to accomplish should one want to accomplish that. And it does take time. As far as Brown Act violations, any individual can go to the district attorney's office and allege a violation of the Brown Act without having procedures like this. Having said both those things, I look at your A to G, and if it's the wish of the commission to proceed forward with this, I would need time to think through A through G and be prepared to come to a meeting and say, A through G, here's what I think about A, B, C, D, E, F. But I don't know that that can be accomplished at a meeting now without prior preparation. I mean, do you agree that censure is, first of all, as a last resort, but can be just done by the word censure and what the understanding of the word censure is in the dictionary?
So I do agree, if I understand your question correctly, that you don't necessarily need a policy in order to be able to censure one of your fellow commissioners. And by the way, despite your question and the context of this, I drafted this without the thought of any specific action or person, or this is just a general policy. However, despite the fact that I think it's true you could censure someone without a policy, I think it would be difficult, it would be risky to do so without a policy. And having a policy in place that describes the conduct that is eligible and subject to censure offers you considerable protection. I would not advise that you censure a fellow commissioner absent the policy. I suppose unless there are circumstances that are so heinous that I'm saying this, I could imagine a censure being appropriate even absent the policy, but it would not be ordinarily the case, as you indicated, is a last resort.
And can you speak just briefly to the Brown Act violation allegation where an individual could go, he or she, to the district attorney's office with a complaint?
Yes, you accurately stated that someone who thinks that the commission has violated the Brown Act can file a confidential complaint with the district attorney.
I have nothing else.
I think it's reasonable to move in the direction of considering adoption of a policy. And whether that policy is ultimately adopted this calendar year or next year when we have a newly constituted commission is an open question. It's not something that's going to happen quickly. If some sort of policy is adopted this year, then any future commission can certainly modify it, strike it, enforce it, not enforce it, however it is they choose. There has been a lot of question relating to the Public Records Act in the last couple of years, questions about and concerns about confidentiality of closed session meetings. You've raised the distinction between closed session versus attorney-client privilege, and sometimes they're the same, and oftentimes they're different. And so I would simply suggest that if we move forward with crafting a policy, that those two be separately identified, but then they also be also note for each one where both might be involved. And I think that such a policy is good not only for guiding commissioners in their own conduct, but also to give the public information about why they don't necessarily get to hear things that happen in closed session, so that they have some understanding and awareness of that in an appropriate way, just as I asked that the Public Records Act be explained with you looking at the camera, so that the public had some understanding about what they could reasonably expect from the district. So I think it's reasonable to move forward. Whether it happens this year or next is an open question, but that's a bit of guidance I would like to give you at this point in time.
And just to be clear, I am not recommending any course of action, one way or the other.
Any other comments? I think that this has started a really good discussion, and by listening to the comments, I think that this needs a little more evaluation and study by the commissioners, and now that we have a basis to read and evaluate. So I would recommend that this item be continued to the next meeting, and we discuss it a little more in depth, having read this and studied it at our next meeting. So if that's okay with the fellow commissioners?
Yeah, if I might suggest, Mr. President, with regard to the questions, items A through G, I think it'd be reasonable to suggest to the district's council that perhaps he might flesh that out a bit more for the commissioners and for the public, and identify perhaps two different alternatives in answering each question. You know, the different approaches that might be taken that are as reasonably distinct as could be, understanding that it could be a hybrid or just one of those alternatives.
Is that a motion?
I'm simply
We're talking about spending money here.
I'm providing
We
guidance
get
to,
paid a lot of money, so what are we really doing here?
with all due respect, if you ask a question, I assume you want an answer. Apparently not. Thank you.
Yeah, so go.
Would-
Nothing, no action taken.
Do you have, I need a motion in order to direct our district council to further research this.
I'll move to continue the item to the first meeting in December and instruct council to specify a little more clearly items A through G, where we might hit. I don't know how much more specificity you can do, quite frankly. But I do know that at least I need time to look these things over to see what's going on.
I'll second that.
Okay, we have a motion and a second to continue this to the next meeting,
No, first meeting in December.
first meeting in December. Thank you. What's the date for the?
December 3rd.
December 3rd. And the commissioners will, having read this document more thoroughly, we will continue this discussion. Any further comments, questions? Roll call, please.
Commissioner Bernardo?
Aye.
Commissioner Brandon?
No.
Commissioner Holsinger?
Aye.
Commissioner Tucker?
Aye.
President Caravano?
Aye. Motion is approved. Now we can go back to item number 3. Information report procedure regarding billing for legal services. Yeah.
So, Commissioner Bernardo, we started because you had asked me to prepare this memo, so decided to wait when you were here, and all I had said was that I, at your request, tried to summarize what our practices were, and I prepared a relatively simple memo. I if you have any questions about it, or I'm happy to discuss it if you. I hope it's responsive to what you were asking.
Yes, I just wanted to say thank you because I really wanted to just codify on paper how, sort of a flow chart of how it works for the benefit of fellow commissioners as well as the public. And I think this is a really kind of at a glance way of looking at how you do billing for the district. And it satisfies what I needed. Thank you.
I have a question. So I noticed that in response to a request that I put in for invoices from council, legal counsel, I received invoices from Lieber Cassidy or billing statements from Lieber Cassidy Whitmore and also from your firm, and they were blanket redacted. So that means every single bit of content, with the exception of the fee part, was redacted. So there was absolutely no useful information there. And I just find that to be really discouraging. I think that it's important for commissioners to be able to look at the billings of legal counsel. Otherwise, we have no idea what we're spending money on. And I would, appreciate receiving more useful information. I understand the need to redact when the information is being provided via PRA request, but it should not have come to the point at which I needed to put in a PRA request. I should have been allowed to review that information, and I wasn't. And there's something really broken here when a commissioner cannot review billings from council without getting them blanket redacted. So just wanted to, since this is our topic here, wanted to communicate that.
Okay, any other comments on item number 3? Item number 5 is the quarterly investment balance report. We have in front of us. This requires a motion.
So moved.
Second.
We have a motion and a second to approve the quarterly investment business report, or balance report. Any questions, comments?
Yes, just briefly. I would simply note that the balance on hand of liquid assets is a little over $13,100,000. This is down from something over $15 million at the end of June of 2014. Part of the reason for that is previous expenditures allocated and approved in the prior fiscal year but not yet expended, and part of it is because of simply the use of the funds for ordinary expenses, and we do receive real property, our share of real property taxes as well as other receipts on a periodic basis, not on an ongoing basis. Mariana?
It's also because we made the payment to default. We made the early payment to default.
Yes. Okay.
So we have a motion and a second. Do we have any further questions? The roll call, please.
Commissioner Bernardo?
Aye.
Commissioner Brennan?
Aye.
Commissioner Holsinger?
Aye.
Commissioner Tucker?
Aye.
President Caravana?
Aye. Motion carries. Next item is bill and claims. Could we report from the treasurer?
Yes, Mr. President, I've reviewed the bills and claims, and they are in order for your approval in the amount of $246,848.05.
Is that a motion?
So moved.
Second.
We have a motion and a second to approve the bills and claims. Any questions, comments?
I have a comment. I just wanted to point out that our legal costs are really high. We've got fees from Hanson Bridget at $12,164, and we've got fees from Lieber Cassidy Whitmore at $7,331.55. I have no idea what those fees are for because I've not been allowed to review the billings. And I'm going to vote no
Aye.
Commissioner Brennan? Commissioner Olson?
Aye.
Commissioner Tucker?
Aye.
President Caravano?
Aye. Motion carries. We have a staff report starting with the general manager.
Hey,
I'm not acting. You have my report, I'll take any questions.
I have none.
Okay. Next report, the Director of Finance. We have a written report.
I'll take any questions on behalf of the finance director.
Item number 9, Human Resources.
We just have a couple of things to add. We did some discussions, and so this past week, as of November 9th, which is upcoming, we will have, because the commission has put in an acting general manager, we therefore need an acting harbor master and acting assistant harbor master. So we have made those decisions, and the acting harbor masters will be assistant harbor master Draper and assistant harbor master White will be acting harbor master, and we have 2 people that will be appointed to the acting assistant harbor master, I'm sorry, which will be Deputy Harbor Master Coates and our lead maintenance specialist.
Question. Ms. Harris, does it follow that if acting general manager Grindy does not become permanent
Yes.
general manager, he goes back to harbor master, and the other appointments go back to where they were?
Yes,
That's
we've
part
made
of the
these
agreement.
appointments for 6 months because that's I believe the initial appointment for Mr. Harbor Master Grindy is 6 months.
6 months plus, I think, 2-3 month
Yeah,
extension.
and we let them know that we're initially going to make the appointment for 6 months, and then we'll review it and go 3 and
Thank
3,
you.
and make the increase in the salary based on the annual use that we generally have. Also, we're working on the accounting specialist exams, which will be in December. Harbor Master Grindy is going to be doing a harbor worker interview this week, and the budget adjustments for the above positions that we'll be doing will be on the mid-year adjustments. So rather than doing a whole bunch, we thought we would just save them for mid-year.
Okay. Item number 10.
Yes, you have my report, and I'll take any questions.
I have a question. Was there any videotaping of the kite festival or any photo ops?
There's some still photos, and I think that's going into our newsletter. I believe I sent them up. I just can't remember right now if we sent them up for the website or not.
Could you email them to the board so we can see them?
Yeah. Unfortunately, the Kite Festival was greatly attended. However, I have never seen wind not occur at Oyster Point till that day. The only kite flying was the kids running as fast as they could with their kite. But there was a lot of family enjoyment at the event, and it was really well attended. So that's why it was probably not a lot of photos of kites flying.
Yeah.
Thank you. You know, we have committee reports. Opportunity for commissioner statements and requests. The first is making public comment, making public statements limited to 5 minutes. I will start on my right, Commissioner Brennan. Commissioner Bernardo. Commissioner Tucker.
I have nothing.
Commissioner Olson.
I'd just simply like to extend my congratulations to Tom Matoush on his success in the election. Congratulations. Good luck to you.
Okay. Now we have an opportunity for commissioners to place an item on the future agenda. I'll start with my left, Commissioner Olsinger.
No request.
Commissioner
I
Tucker.
have nothing.
Commissioner Bernardo. Commissioner Brennan.
I move to agendize an item on the next agenda to discuss hiring an executive search firm to assist with the hiring process of a new general manager.
Do we have a second? Hearing no second, the motion fails. Any other items?
No.
Okay, this call for an adjournment.
So moved.
December 3rd.
Second.
We have a motion.
No.
Oh, I'm sorry, yeah, November 19th, sorry. November 19th. Okay, roll call.
Commissioner Garvelia?
Aye.
Commissioner Brennan? Aye. Commissioner Olson?
Aye.
Commissioner Tucker?
Aye.
President Fairwell?
Meeting adjourned.